I'm making my now legal submissions on based on that. So what they did, before even adding those sections, those offenses in ECIR, they referred in my grounds of arrest. So therefore, it was the satisfaction or exercise powers under section 19 is excessive. If my grounds of arrest is per use, then those FIRs which were added on 21/11/2025 was found while I was arrested on 3rd October. It is not permissible, and therefore exercise of powers under section 19 is either vitiated or does not maintain the high standard safeguards as observed and stated by the Honorable Supreme Court in Vijay Mandala. For that, Lordship may see this is first my ground P of my bail application. Yes, therein is Honorable Supreme Court in Vijay Mandala in para 322 with respect to the section 19 of the 2002 Act postulates the manner in which arrest of a person involved in money laundering can be effected. Subsection 1 of section 19 envisages that as a director, deputy director, assistant director, or any other officer authorized in this behalf by central government, if has material in his possession giving rise to reason to believe that any person has been guilty of an offense punishable under section so and so, he may arrest such person. Besides the power being invested in high-ranking officials, section 19 provides for inbuilt safeguards to be adhered to by this authorized officer, such as the recording reasons for his belief regarding the involvement of a person in an offense of money laundering. That has to be recorded in writing while effecting arrest of the person. The grounds of such arrest are informed to that person. Further, the authorized officer has to forward a copy of this order along with his material in his possession in a sealed cover to the adjudicating authority, who in turn obliged to preserve the same for the prescribed period as per the rules. These safeguards is to ensure fairness, objective, and accountability of this authorized officer in forming opinion as recorded in writing regarding the necessity to arrest the person being involved in offense of money laundering. Not only that, it is also the obligation of this authorized officer to produce the person so arrested before. Then it is about the production. Then section 19 is copy. I'm not reading those part, my lord. Then Lordship see para 323. The safeguard provided in 2002 Act and the proceedings to be fulfilled by the authorized officer before effecting arrest as contained in section 19 of the 2002 Act are equally stringent and of higher standard. Those safeguards ensure that the authorized officer do not act arbitrarily, but make them accountable for their judgment about the necessity to arrest any person as being involved in the commission of offense of money laundering, even before filing the complaint before the special court under section 44(1)(b) of this Act. In that regard, if the action of the authorized officer is found to be vexatious, he can be proceeded with and inflicted with the punishment specified in the section 62 of 2002 Act. The safeguards to be adhered by the jurisdictional police officer before effecting arrest as stipulated in 1973 code are certainly not comparable. Suffice is to observe that this power has been given to the high-ranking officials with further conditions to ensure that there is objectivity and their own accountability in resorting to arrest of a person even before formal complaint is being filed. So therefore, my contention here that by amendment was of 21/11, then there was no reason, no scope for them to refer those other offenses in my grounds of arrest. So there's a power exercised in the section 19 to arrest me when I was in judicial custody of this scheduled office where they have interrogated me. So therefore, this exercise is absolutely beyond the powers of their or their exceeded power. Second, my contention is that the ground Q with respect to section 35 of the BNS. When this offense is punishable up to 7 years, when I was available to them, I was being interrogated with the permission of this honorable court in the judicial custody. And there was no flight risk because I was being in judicial custody at that time. So there was no reason was being made to arrest me, and there was no material available on record. Because on that day, there was only the first FIR of the Surat. Then the next contention is presumption. For that, lordship may see there is a ground U. When presumption would be available? Presumption in section 24. They say there is a presumption available at this stage. That is not correct. That presumption is at the stage of trial, not at the stage of bail. Because I don't have a chance to rebut this presumption at this stage. Lordship may see there's one paragraph quoted of the Vijay Madanlal in ground U. Be it noted that is a legal presumption under section 24A of the 2002 Act would apply when a person is charged with this offense of money laundering and his direct or indirect involvement in any process or activity connected with the process of crime is established. This exercise of process of crime is therefore a foundational fact to be established by prosecution, including the involvement of a person in any process or activity connected therewith. Once these foundational facts are established by the prosecution, then ownership, say, the owners must then shift on a person facing charge of the offense of money laundering to rebut the legal presumption that is the process of crime and not involved in money laundering by producing evidence which is within his personal knowledge. So this stage will not come at this stage, it will be at the stage of trial. Then lordship may see the section 3 about what is the ground double B, double C and double D. There is a street stage of the money laundering, my lord. Double B, double C and there are three stages to establish money laundering. First is there is a placement, second is layering, and third is the integration. The double B, double C, and lots may see in the double D. What does the Supreme Court said in Vijay Madanlal? I'll straightway go to the in double B and double C I have explained, and double D this is what the exactly Supreme Court of this is not able. They are not able to show on facts. Okay, these three requirement is satisfied. Lordship may see what the Supreme Court said in para 271. As mentioned earlier, the rudimentary understanding of money laundering is that there are three generally accepted stages of money laundering. They are placement, which is to move the funds from direct association of the crime, layering, which is disguising as a trail to foil pursuit, and there's integration, which is making the money available to criminal from what seemed to be legitimate sources. Now, nothing has been established against me, not even any averment against me of either of these three requirements. So, ingredients of section 3 is not satisfied. Then, lordship may see the twin conditions about the section 45 for the bail. For that, ground double E, double I, and double L. Double E, double I, and double L, where I have quoted the relevant judgments. The first judgment on this issue in the matter of Ranjit Singh Sharma, in the matter of Makoka, my lord.
Yes.
Yes, my lord, see this is a ground double E, where I have quoted the averments in the Anil Deshmukh, which relied on this Ranjit Singh Sharma as well as the Ranjit Singh Sharma referred in Vijay Madanlal. Both lordship may see that para 35 is the Ranjit Singh Sharma, lords may see in double E. A useful reference in this context can be made to a 3-judge bench judgment of the Supreme Court in the case of Ranjit Singh Brahm Singh Sarma versus State of Maharashtra, wherein is the courts of the power of the court to grant bail in face of the indirect contained in section 21(4) of the MACOCA arose for consideration. The indirect against the grant of bail under section 21(4) of the MACOCA is perimeter as contained in section 45(1) of the PMLA. In Ranjit Singh Sarma, the Supreme Court illuminated postulate this approach to be adopted in arriving at the satisfaction as to whether the accused is not guilty of such offense and the accused is not likely to commit any offense while on bail. They read as under. Then section 35, para 35 of Ranjit Singh Sarma said, whereas the Supreme Court said at the bail stage, court is not required to hold guilty or not guilty. What it has been in the reply, they say these honorable court must say at this stage, well, I'm not guilty. If that is to be held at this stage, then there is no requirement of trial. Now, this is what the Supreme Court in Vijay Madan Lal again relied on. These lots may see page 25 bottom in the same quotation in ground B. That para 400 is quoted, that is from Vijay Madan Lal. It is important to note that is the twin conditions provided in section 45 of 2002, that's a PMLA. Though restrict the right of the accused to grant of bail, but it cannot be said that the condition provided under section 45 imposes absolute restraint on the grant of bail. The discretion vested in the court, which is not arbitrary or irrational, but judicial, guided by the principle of law as provided in section 45 of the 2002 Act. While dealing with a similar provision prescribed in twin conditions in MACOCA, this court in Ranjit Singh Sarma held as under. Then 401. We are in agreement with this observation made by this court in Ranjit Singh Sarma. I'm not reading because that's already referred it earlier. My lord, so no, I'm not. So Supreme Court in for MACOCA observations had been followed in PMLA. We are in agreement with this observation made by this court in Ranjit Singh. The court, while dealing with this application for grant of bail, did not dwell deep into the merit of the case, and only view of the court based on available material on record is required. The court will not wait the evidence of to find the guilt of the accused, which is of course the work of trial court. The court is only required to place its view based on probability on the basis of reasonable material collected during investigation, and the said view will not be taken into consideration by the trial court in recording its finding of the guilt or acquittal during the trial, which is based on the evidence adduced during the trial. Therefore, what I'm submitting is that this honorable court is not required to go into that standard that I'm not guilty. Then only bail can be granted. Then double and lordship may see. Wherein there's a Prem Singh.
No, Prem Prakash.
Yes, Prem Prakash. Sorry, stand corrected. Prem Prakash versus so and so. In para 11, the Honorable Supreme Court, considering that there's a present is a bail application for the offense under section 45 PMLA, the twin conditions mentioned thereof become relevant. Then I'll skip the reading of section 45. Then lots may see after section 45 at page 38 bottom. In Vijay Madan Lal reported in Soju, this court categorically held that while section 45 of PMLA restricts the right of the accused to grant of bail, it could not be said that as a condition provided in section 45 impose absolute restraint on the grant of bail. Para 131 accepted. As you seen in the original judgment, para default, otherwise it is the same paragraph. 131, lots missing. It is important to note that the twin conditions provided in section 45 2002 Act so restrict the right of the accused to grant bail, but it cannot be said that the condition provided in section 45 imposes absolute restraint on the grant of bail. The discretion weighs in the court, which is not arbitrary or irrational, but judicial, guided by the principle of law provided in the section so and so and so. These observations are significant, and if read in the context of the recent pronouncements of this court in so and so Manish Sisodiya, it will be amply clear that even under PMLA, the governing principle is that, now kindly mark this, bail is the rule and jail is an exception. Now, this has been not only said in Manish Sisodiya, it has been said in Shiv Kumar, it had been said in P. Chidambaram also. So in PMLA also, bail is the rule and jail is an exception. That is in number of judgments the Supreme Court said, my lord. Lords may see, there's a quotation in Manish Sisodiya, paragraph 53. From our experience, we can say that it appears that the trial courts and the High Court attempt to play safe in matters of grant of bail. The principle that bail is a rule and refusal is an exception is at times followed in breach. On account of non-grant of bail, even in straightforward open and shut cases, this court is flooded with a huge number of bail petitions, thereby adding to this huge pendency. It is high time that the trial courts and High Court should recognize as a principle that bail is the rule and jail is an exception. All that subsection 45 PMLA mentions is that the certain conditions are to be satisfied. The principle that bail is the rule and jail is the exception is only a paraphrasing of Article 21 of the Constitution of India, which states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. So therefore, the principle that is the bail is the rule is still holds even in PMLA, and that's been recognized by the Honorable Supreme Court. That is my next contention is on proceeds of crime ground double H.
Double H.
Double H.
Yes.
Just give me. Yeah, again, where there's a Anil Deshmukh, I have quoted, my lord. What is a Anil Deshmukh again is Vijay Madan Lal is been quoted. That para 250 to 51. The Lords may say straightway go to para 251, what has been quoted on page 30. May read my lord, para 251 straightway to save the time. The process of crime being one, being the core of the ingredients constitute the offense of money laundering. The expression needs to be construed strictly in that all properties recovered or attached by the investigating agency in connection with the criminal activity relating to a schedule offense under the general law cannot be regarded as a process of crime. There may be cases where the property involved in the commission of schedule offense attached by the investigating agency dealing with that offense cannot be wholly or partly regarded as process of crime within the meaning of section 21U of the 2002 Act, so long as the whole or some portion of the property has been derived or obtained by any person as a result of criminal activity relating to the stated schedule offense. To be process of crime, therefore, the property must be derived or obtained directly or indirectly as a result of criminal activity relating to a schedule offense. To put it differently, the vehicle used in commission of schedule offense may be attached as property in the concerned case crime. It may still not be process of crime within the meaning of section 21U of the 2002 Act. Similarly, possession of unaccounted property acquired by legal means may be actionable for tax violation and yet will not be regarded as process of crime unless the concerned tax legislation prescribes such violation as an offense and such offense is included in the schedule offense. For being regarded as process of crime, the property associated with the schedule offense must have been derived or obtained by a person as a result of criminal activity relating to the concerned schedule offense. This distinction must be borne in mind while reckoning any property referred to in schedule offense as process of crime for the purpose of 2002 Act. Dealing with process of crime by way of any process or activity constitute offense money laundering. Then para 253 also describes the questions of what is the money 252, and then lots we see on page 33 to 53. I'll just read this highlighted portion. Page 33, quoted para 253. Thusly put it, only such property which is derived or obtained directly or indirectly as a result of criminal activity relating to scheduled offence can be regarded as process of crime. The authorities under 2002 Act cannot resort to action against any person for money laundering on an assumption that so therefore no scope of assumption. What they say section 24 apply. Supreme Court says no. The authority under section 22 Act cannot resort to against any person for money laundering on an assumption that is a property recovered by them must be process of crime and that a scheduled offence has been committed unless the same is registered with the jurisdictional police or pending trial by way of the complaint before the competent court. Then after there's a quotation, lots may see in that it has to be already accomplished. Those three C, this I have to say, three stages of this ingredients of section 3. In that context, Supreme Court said any of the stages 1, 2, 3 are 3 stages. If all the 3 stages are completed, then only it can be an offence. It's like the 138 notice. The mere dishonour of the check is not an offence. Once the notice was issued, is not an offence. But after issuing the notice, payment is made, then offence is not made up. So that's kind of similar kind of analogy can be here. If there are all the 3 stages has to be completed, then only it is an offence. That is made very clear. Then is the next. It's a triple test. That is a ground double J, my lord. I have referred to 2 decisions in that. Dr. D.K. Shiv Kumar, where there is a test of triple test, the Supreme Court evolved, is a flight risk, tampering of evidence, and influencing witnesses. If my passport is being surrendered, there is no question of flight risk. Tampering evidence, all the entire case is based on the documentary evidences, and they are already collected. Almost for more than 6 months, I'm in judicial custody from October here, but in schedule offence, I was prior to that also. So there was no question of now tampering of evidence. If my total period of incarceration has been taken, is much more, my lord. And then in the same paragraph, P. Chidambaram also does, I have quoted, my lord, there's a in that the same paragraph, P. Chidambaram, that what the Supreme Court said in para 23, that is a basic jurisprudence relating to the bail remains the same, inasmuch as the grant of bail is the rule and refusal is exception, so as to ensure that the accused has opportunity to securing fair trial. Now, in the case of P. Chidambaram, he was an influential person, he was an MP, he was a high-rich people. All those ingredients of fair risk were there. That I am a small person against, if I'm pitted with this Mr. Chidambaram, then those ingredients of the requirement will not satisfy. If it has been satisfied on his case, it's definitely satisfied in my case also, the triple test, my lord. Then on the question of non-cooperation, that ground double P, lordship may see. There I have quoted 2 decisions. Merely not confessing the crime or merely not responding to the questions as per their desire does not amount to non-cooperation. Lordship may see it is in Santosh and in Pankaj Bansal. What does the Supreme Court say? Even in a recent judgment in the anticipatory bail, Supreme Court does ask the person accused to appear before the investigation agency. He appeared before the investigation agency. I'll get that judgment also, my lord. And the prosecution made a complaint to Supreme Court that he has not given his mobile phone. Supreme Court said, no, it is your case. One cannot be compelled to give evidence inculpatory. And Supreme Court granted anticipatory bail. I'll give that copy of the judgment, my lord. Now, this is before that. The purpose of custodial interrogation is not just for the purpose of confession. The right against self-incrimination is provided in for Article 22(3) of the Constitution. It is well settled position in view of the Constitution when judgment in so and so enjoys and alleged status. This provision is an essential safeguard in criminal procedure and is also meant to be a vital safeguard against torture and other coercive methods used by investigating authorities. Therefore, merely because the petitioner did not confess, it cannot be said that he was not cooperating with the investigation. So this was relying on this plus one more that judgment. I say this merely there, I did not answer to their satisfaction or did not say yes when happened, have you made crime? I said no, then it cannot be said not, or I have not made available any information. Because I did not know. They say USDT, cryptocurrency. I say I don't know. That they say I have not cooperated. So that is not as a non-cooperation. That is the Supreme Court said very clearly. Then the next ground double Q, my lord. The prosecution has to prove their case beyond reasonable doubt. Lords may see this was in J. Sekhar. Para 18 I have quoted in ground double Q. The principle of criminal law still remains here the same. To prove beyond reasonable doubt. They are not supposed to go on preponderant probabilities.
Yes.
Yes. I have quoted as the J. Sekhar, my lord. In our opinion, even in cases of PMLA, the court cannot proceed on the basis of preponderance of probabilities on perusal of the statement of the object and reason specified in PMLA. It is the stringent law brought by the parliament to check money laundering. Thus, the allegation must be proved beyond reasonable doubt in the court. Even otherwise, it is incumbent upon the court to look into those allegations and the material collected in support thereof and to find out whether the prima facie offense is made out. Unless the allegations are substantiated by authorities and proved against the person in the court of law, the person is innocent. So therefore, with these observations, jail is the rule, bail is the rule and jail and exceptions. Bail is to be granted. Then the last contention, my lord. The ground double S and double T. This is on the line. There is a prosecution is in PMLA is not to be tried for the schedule offense, or they are not required to prosecute me for the schedule offense. They need to prosecute for the PMLA only. Let's may see what the Supreme Court said in para 284. In other words, the authority in the 2002 Act is to prosecute a person for offense of money laundering only if it has reason to believe, which is required to be recorded in writing, that a person is in possession of proceeds of crime. Whereas in my case, when I was being arrested, those 5 FIRs were not the part of the ECIR. Even then they recorded in reasons to record. That is not permissible under the law. This is high standards required. Highest authorities been given this powers to arrest with safeguard, and Supreme Court said in so many words. In spite of that, nothing has been followed. That's what I say that my arrest is in violation of Section 19 because I had searched so many things on Section 19 in my bail application. They consistently said no, we have given the grounds of arrest, we have given this arrest memo. That's not mere formality of supplying document is not sufficient. What is to be sufficient? You need to adhere to the law. You need to adhere to the sections. You need to adhere to the dictum or the binding ratio of the Honorable Supreme Court. That has not been followed in my case, and therefore bail is required to be granted. And I have been granted this on the same material. Honorable High Court has granted me bail on this schedule offense. Lots of it. I have the full set of all these judgments also. I can supply if my lord requires.
You have quoted all those.
That's what.
The material relevant you already expected and produced.
Yes. Otherwise, how this I kept ready this the full set of the judgments also. Please.
10-15 minutes.
You'll be able to deal with all his contention.
Yes, around 15 minutes I would be.
You go through it, but you will
I'll be
required
restricting to the bail and the contentions raised by the applicant.
each contention will be required to be
Yes, sir.
starting from ground for arrest and
Yes, yes, sir. I'll deal with all.
have that time.
Yes. Draw the attention of the honorable court to firstly to the exhibit one, because they have raised some arguments in regarding which it could be relevant to know. Exhibit one, page number 1, sir. Whereby the honorable court would find the memo of the petition.
Where is exhibit one?
But their application filed by the applicant. The memo of the application.
Yes, what is it?
The honorable court would find that against the name of the applicant, the address is mentioned there, sir, of house number 10 by 2025, B4 Safaya Mandir, Soni Palia, Surat. It is the same address, sir, whereby the accounts related to which were utilized for diversion of funds and creation of the crime money. It was seized from this very premises, which the applicant claimed to be his father and not his own. So he cannot run away by saying that this is my father's address and I cannot be made guilty for when he himself disclosed his address to be of the same. Secondly, sir, I would also like to place on record the grounds of death and reasons to believe, which were collectively not placed before the honorable court, whereby at page number 1 of the ground of arrest, 1 and 2 continuing on page number 2, and at page number 5, sir, page number 6 continuing on page number 7, the honorable court would find the 5 FIRs which were very much part of the ground of arrest and the reasons to play at the time when arrest was made of the present applicant. Now the contention raised on behalf of them, the applicant, was to the effect that this material was never under consideration before the filing of the present prosecution complaint. However, the honorable court would find that the ECR was recorded on 26th of March 2025. The ECR is the initiation of the investigation. It cannot be expected that every fact would be there part of the ECR. It would be only after investigation and further proceedings that the role of the applicant would come on record. So only at the time of arrest, all these facts were duly taken into consideration, and only after the arrest was effected of the present applicant. Now, sir, so far as the role of the applicant that has come on record, firstly, sir, at this juncture, the honorable court has to see that what is actually is the burden and upon whom, sir. The present applicant has to prove 2 things: that there are reasonable grounds of believing that he is not guilty of the offense of money laundering, and there is no possibility that he would commit any offense whatsoever if he is released on bail. As against that, on broad probabilities, it is not that I have to make out the case beyond reasonable doubt, because the relevant judgment they thought they have read into was J. Shekhar, which is not on bail. At this stage of bail, I have to make out a prima facie case that exists against the applicant for applicability of the twin conditions. Now, coming to the role of the applicant that has come into
the idea.
Pardon, sir?
He says here to raise
But
the
yes, sir, he has
presumption.
read into the judgment of J. Shekhar, which is not on bail, sir. So, sir, the role of the present applicant is to the effect that he has cheated and lured various persons by putting them into digital fraud or putting them into digital arrest and extorting money from them. And all this money was accumulated by the present applicant in connivance with other accused persons into various accounts, which was opened in the name of third party, but this very applicant was having the complete control over all those accounts. He has utilized that account for accumulation of the fund, which was later on diverted to later layered or diverted through various other accounts, again opened and controlled by the present applicant, and was withdrawn in cash. Apart from that, he has also converted the same cash which was withdrawn into USDT, and thereafter laundered it through Hawala transaction to countries abroad. And even there has been the WhatsApp chat which has recovered from the very present applicant, which show that his very involvement. When the investigation was taken up, the account opening form and KYC details were sought, which by it was found that this very applicant has utilized the accounts of various other individuals for generation of funds for converting and layering it to various amounts and diverting it into cryptocurrency and thereby routing it out of the country through Hawala transactions. The photos of the currency notes has also been found from the chats of the present applicant, which would show his involvement into Hawala transactions. Apart from that, his own very account, sir, has been there has been found that it has entries to the tune of around 5.12 crores, and his wife's account was also having an entries with respect to around 1.75 crore. So all in all, sir, his involvement has to be seen at the very juncture, and his activity of concealing of the proceeds of crime is also, because concealment portion is also one of the facets of the ingredient under section 3. The Honorable Court would see that various statements under section 50 was also recorded. The first statement would be RUD 70, sir, of Abrar Khan Pathan, whereby he has stated that the present applicant had opened the account in his name, which was maintained with IDFC Bank, and he was operating it to monitor, and he was operating and monitoring the same account for diversion of funds. It was the present applicant only who was withdrawing the cash. Even the cash checkbooks and the bank account statement and bank passbook everything was in control of the present applicant. On the similar lines, the statement of Danis Murtaza, RUD number 72, is also to the same effect. He has 72. He has even stated that the very mobile number which was linked to this account was in control of the present applicant. In addition to that, he also used to manage the cryptocurrency and USDT transactions. The statement of Nawaz Chandira, RUD number 100, sir, is also relevant. He has stated that he used to convert the USDT on the instructions of the present applicant, and he used to take cash from the present applicant, which would range from per transaction 10 lakh to 35 lakh. When the present applicant was confronted with the WhatsApp chat and the record which was found from his WhatsApp, which would show the various transactions, he has stated that although the chat is his, but he cannot explain that why he has carried out the same, and why he has shared the details of crypto wallet, the details of various accounts which was found from the which was seized from the very applicant's address, and why he has carried out, thereby coming up with no explanation whatsoever to discharge the initial burden under section 24. Now we cannot, it cannot be right that I am not coming with the explanation that is to the satisfaction of the IO, but for what purpose and for what nature the transaction was carried out by him, that is within his knowledge, which he has concealed. The Honorable Court, I would use USPP. Please to see the relevant RUD number 85, sir. At page number 8591 would be very relevant for this, sir. Whereby at the end of page number 8591, 85, page 8591 of the RUD, the 8591, the RUD number, sir. It is given at the top, sir. The PDF would be page number 2, but internal page would be 8591. Whereby at the end, the Honorable Court would see that the identity card of some resident of Dubai, and whereby under which it is written that 2 million dene hai, call karke bula le, and would again find the transaction details thereafter. The transaction of into USDT, whereby the again at some page.
Which point you want me to read?
Sir, 8591 are the page number. The chat with Al Amidi would be there.
Maybe page number 361.
The internal page would be there. 8591. The second page of the PDF would be there. I'll. 85. The chat with Al Hamidi would be there, sir, whereby he has shared the identity card, resident identity card, and it is written that 2 million देने हैं, call करके बुला ले. And thereafter again the transaction would come into place. And thereafter the honorable court would see that number of transactions has been carried out by him on his instruction. Some paid to the resident outside India, and at page 8513, sir. 8613. The honorable court would find the relevant currency note of the UAE, which 8613, page 7 of this PDF. Sir. The currency note would be there, sir, whereby it has been used for carrying out the Hawala transactions by this very applicant. And on the very next page, the currency note of ₹10 would also be there. Again, some payment has to be made for that currency note on the instructions of this very applicant. And there are around 400 pages of this very ROD, which would be having the similar transactions and which was carried out on by the present applicant or on the instructions of the very applicant.
It also has samosa, water, soda.
Pardon, sir?
The message also have 30 samosa, 40 water, 60 soda, 140 palam bar.
They must be with getting hungry after carrying out such lengthy transactions. So certainly it would require some food for them.
Some food also.
Now, sir, coming back to the role of this present applicant, sir. Again, sir, one person named Mohammed Zaid, the statement is also relevant. ROD 104 of the PC, whereby he stated that he has started trading in cryptocurrency and he used to purchase USDT from Kashif, and against that USDT he used to pay cash to the very applicant, sir. And even, sir, his WhatsApp chat with Mohsin Sheikh is also relevant, whereby number of transactions has been carried out by him. So considering the very role of the applicant for the generation of feet of crime, thereby layering it through various USDT transactions, crypto transactions, and carrying out Hawala transactions for concealing the proceeds of crime is very much applicable for the present applicant. And the section 3, the ingredients would be stand satisfied for the present application so far as the generation, layering, and concealment part is concerned in the present offence. Now, sir, considering the role of the applicant and the material placed on record as I've shown in the relevant ROD.
Now, what is this message? He puts the photograph of 10 rupees notes.
Sir, it is for carrying out because there would be some unique number to that currency note that would utilize for making the payment or carrying out the payment through Angadiya firm or Hawala transaction, because that currency, the payment would be made only to that person only who would be showing this very same currency note with the same number. That is how it operates.
Okay, so if this number is sold to the Angadiya, then that can be.
They will make the payment, and even the this same transaction has been carried out through UAE based currencies, because he has stated himself to be the resident of Dubai, so he has been carrying out the similar activities. And now one of the ground that is raised that I only proceeds of crime to the tune of 5 lakhs has been recovered from him. But it does not, because he has concealed the remaining proceeds of crime. He cannot claim that if that is not found from my possession, I cannot be attributed the role as narrated in the prosecution complaint. So, sir, considering this very role of the applicant, it cannot be said that there are no reasons to believe that he is not guilty of the offense of money laundering, sir. And moreover, sir, if it is taken into account that digital platforms has been utilized by the very present applicant, and extortion and digital arrest has been the one of the modes of generation of proceeds of crime. So possibility of tampering and dissipating the remaining proceeds of crime cannot be ruled out for the present applicant. And but the discretion may not be granted in favor of the applicant.
Answer in 5
Sir, I placing the relevant roles of the and with the relevant RUD, sir.
ये एडेंडम इसी आर्ग्यू के सब्जेक्ट में आपने बताया कि हमारे आर्ग्यू में फिजिकल
Yes.
that would require for my not I'll just answer this what my learned friend has argued.
Yes.
Yes, I have not admitted that rupees 5,70,000 is a process of crime. I say they have attached my property against the allegation of 104 crore. That's all. Otherwise, I have not admitted. Number one. Number two, then is what my learned friend by referring RUD 70, 72, 100, 85, and 104. They say that I was involved in the Hawala transaction or some monetary transaction. These are the private complaint. To make out a case, there has to be a specific government in the private complaint. There are the principles of criminal law is a different in context with the FIR, charge sheet, and a private complaint. Private complaint has to make a specific government against the specific accused to make out a case at least on fact. They may not state anything on law. What they do, they copy all the provisions of the PML which are relevant in the complaint, but they don't state anything on the facts. So there is no averment about any transaction with RUD 70, 72, 100, 85, 104. There are no statement on record to say that what are the transactions that have been reflected in those RUDs have actually happened. There is no evidence. There is no evidence that against those currency notes have been shown, payment has been made or transferred. There is no statement of any person that payment received or given. There is no statement of any Angadia people that against these currency notes payments were being made or taken. So there is no such evidence available on record. Then my learned friend says that there are bank entries in my accounts of 5.2 crores and in my wife's account 1.75 crores. So I am a resident of Dubai. I am doing business in Dubai, and there is a currency change exchange reflects the almost 25% of the Indian rupees. So any amount which is my legitimate business has come, that cannot be termed as a straightway process of crime. The Honorable Supreme Court, Vijay Madalal said, I have read one of the ground where the Honorable Supreme Court made those two examples. Even if the vehicle has been used, it may not be process of crime. Even if unaccounted money is not the process of crime. So they need to not only say that money is there in my account, it could be unaccounted money. Or it could be this, because whether it should be seen whether it is unaccounted or accounted in terms of the Dubai law. If I have any transactions in Dubai and the money is being transferred to India in my account, it does not become strictly a process of crime. Then my learned friend says UODT and Hawala. When I have been put to question, I specifically denied that I am not involved in that, I do not know about it. When I am denying it, then they need to prove it. Then they say that I was in control of those accounts which have been opened in the third party's name. There is nothing on record to show that I had operated those accounts or the money was withdrawn by me. There is no evidence to debate. There is no evidence. I am repeating I did argue in my argument. There is no time official statement that I went and opened those accounts or I operated or I withdrawn those money. No evidence to that effect. Then my learned friend says that is in the grounds of arrest about those efforts. That's I said, yes, they made this submission of those other FIRs in grounds of arrest, but before adding to the ECIR. If they say this was not required to be added, then why they on 21st 11th added it? Addendum was not. So therefore, their own submissions are conflicting with each other. If it was not required, then why did you add it by addendum of dated 21st November? Because on that day, it was not a part of the ECIR. So that was my contention that on the date of my arrest, ECIR was limiting to Surat offense only and referring those to FIRs in my grounds of arrest is exercised beyond section 19 of their powers. Therefore, they will be granted.
So just one submission. Just one. That first,
Almost more than 1 hour has been devoted.
just last submission that firstly he they state that this is about the legitimate business. But what was the legitimate business? They have not given any explanation and merely denying it and not coming up with an explanation and now saying that it was my genuine business transaction. But again, revealing not
Judgment is very
what-
clear on this aspect.
that cannot be circumstantiated at this.
Please.
Please, I'm obliged.
Obliged.
So as per the schedule offense, there is only one schedule offense. So paragraph number 1, this is the total process of crime as per section 2U. What is the process of crime? First, 4.5 crore cash which is extorted by accused number 1 from Dhawan Mawani. Admittedly, I have nothing to do with that amount. I am not concerned. Then second, third number, 2091 Bitcoin extorted by accused number 1 from Dhawan Mawani. And 4, 200 Bitcoins transferred by accused number 1 from the gadget of Dhawan Mawani. And then number 5, 11,000 light coins. Now, as far as I am concerned, only accusation is out of these item number 3 and 4, out of these total 2,291 Bitcoin. There are 3 different versions. As per my statement, which is recorded, it is recorded out of 3,291, 260 Bitcoin is transferred. As per the record of that wallet, the department has seized and investigated. 200 Bitcoins were transferred from accused number 1 to my account. And another statement is out of those 200 Bitcoin, 260 Bitcoin, 240 Bitcoins were converted into USDT and transferred to Sanjay Kotaria. Now, my friend, Appellate Police Department has said that it is the only statement of that accusation, nothing else. So that is contrary to their affidavit. That is contrary to the results recorded while arresting me. What my friend is arguing today, it is contrary to their evidence made on both state and affidavit itself. Forward, my friend, I turn to page number 25. Grounds of arrest.
Yes, you
So
would
there
be.
cannot be anything beyond
Yes, yes.
detail. Because there cannot be anything beyond this process of crime. Suppose they would say that I have another 50 properties, thousands of other Bitcoins or thousands of crore case rupees. These are the only process of crime. There is no any other allegation against any of them. Now your main accused who extorted 2,291 Bitcoin along with 14.5 crores of rupees cash and along with 2,091 Litecoin. Now, Maharashtra, as per the case of the ED, what is allegation against me? Page number 24. That is the arrest order. Grounds of arrest start from page number 25. I will not take first, will not do the relevant paragraph only. Not page number 26. Paragraph number 4. This one friend is saying that there is only my statement and nothing beyond that because I am reading it. Not before paragraph number 4, which is recorded the statement of accused number 1 is recorded. Then paragraph 4 and page number 26.
Yes.
The investigation, what is investigation has revealed that you have received a huge quantity of Bitcoin, 46 Bitcoin. That is the only allegation. I may read further. From the labor, knowingly said Bitcoins were generated from the schedule offense to another. So you knowingly entered, purchased, converted, extorted Bitcoin into USDT. Now, this is also further strengthened along with the evidence of that Binance account of Sanjay Kotaria and statement of Sanjay Kotaria, where it is also on record that after converting this Bitcoin into the USDT, that account of that tourist was to the account of Sanjay Mumbai. I may read further. Origin fund. You transferred approximately 23 lakh USDT derived from extorted cryptocurrency to Sanjay Kotaria for trading and admitted that no cryptocurrency money has been returned till date. So this is the investigation reveals expertise of the department. Then paragraph number 5. You were fully aware that so-and-so was an accused and absconding in a serious criminal case at the relevant of time that crypto assets were received by you and were not from any legitimate source. Despite such knowledge, you continued to handle, convert, and transfer the same cryptocurrency. Then, my lord, this is important. I will read it now. Bharat, you can bear with me. This paragraph number 503, this third line, assets and thereby knowingly assisted in concealing possession, use and processing process of crime. So what is allegation against me is I have assisted in an accused in transferring of this process of crime. What is process of crime? To 40 Bitcoin coin. I will read further. Then, sir, paragraph number 8. So this is the only allegation. Now I may come to that affidavit only. There are 3 affidavits filed by them. First is dated 9th of February 2023. Further being there, paragraph number 3.1. This is what is the case of the department that 2,200 Bitcoin, the accused number 1 is extorted. Then paragraph number 3.3.
Yes.
The very same that it is 14.5 crores of rupees, then it is the light point, Bitcoin. Then paragraph number Roman 2 and internal page number 4. Details of all such Bitcoin are there from the wallet details. So it is not so that the details are not there and only statement of the equity is there. Though that statement record in the table 50 is applicable. Now what is for the department is saying that accept the statement there is nothing. But there is something on record. Roman 2, internal page number 4. So this is the details of that Bitcoin.
Yes.
Then second last paragraph of last paragraph of the internal page number 5. This is the details of total Bitcoin. Then sir, what is nexus with this accused person is also stated by the department. At page number, internal page number, start from page number, internal page number 7, paragraph number 3.4. It is titled as nexus of misuse with the proceeds of crime. Now relevant to this next page, Roman 4. Then along with my statement, what are the other materials from record to support that contention? This is further. The amount may vary, otherwise fact remains same. Roman 4. Including but in his statement dated 2022 stated that he has received 260 Bitcoin from his identifier. Then we, out of 260 Bitcoin, he transferred 2022 Bitcoin to the Binance wallet and returned to 40 Bitcoin to the identifier. As per his statement, instructions within the reported, and out of 19.5 Bitcoin transferred by him, the Binance account number 12 was different. Then આટલા જે જેટલા Bitcoin મારામાં હતા, જેટલા એકાઉન્ટમાં પડે છે, that is different. Because of the Bitcoin identity also. એટલે મારે એકાઉન્ટમાં જે હશે મેં ડિટેલ કર્યું, જે સિવાય બાકી ક્યાં ટ્રાન્સફર થયું, એની ડિટેલ બી છે. હવે સાહેબ રોમન 4. Roman 4. He is saying that except this statement, there is nothing here.
Yes.
That what the department is saying, Roman 5, the internal page number 8. During the further investigation conducted by the department, as per the forensic analysis and Bitcoin wallet of the instruction first, the document obtained by the technical directorate it reveals that at least 200 Bitcoin were transferred from the wallet of the investor to the wallet held in the name of Sunil Gardelbach. So what is the on record expert wallet is out of 2,291 Bitcoin, only 200 Bitcoin were transferred. person who extorted 2,291 Bitcoin is released on bail. What is allegation against me and what is material on record is out of that, those Bitcoin, only 2,000. In my statement, I have said 260. Involuntary evidence is at 200. But that demanded beyond 260, there is nothing.
Yes.
And this is the base case of the department. Another further clarification, page number 9. Before that, the last line of page number 8. What they are saying, last line. During the state search proceedings, search proceedings, what revealed? That is what department is saying. During the search proceedings on Second 2025, Inter area is revealed. They A. Sunday quoted and open that amount. Then B. That this is the details of account which is registered in finance. Then C. That amount, the cryptocurrency which is transferred is relevant and important. That all the cryptocurrency, so and so, received by equal word in the same ID account are transferred from the account of Sanjay Kudiyalwar to Sanjay Kotaria. But this is the evidence on record, and this is further strengthened by the statement of Sanjay Kotaria. And Sanjay Kotaria said, ground of arrest not yet. That is what.
Yes, anything more now? Yes.
Yes. So firstly, sir, I'll deal with what is the total proceeds of crime in this case, sir. Firstly, there was an extortion of 14.5 crores. Secondly, the extortion of bitcoins to the tune of 2091 crores. Sir, the role of the present applicant for the very purpose of generation of proceeds of crime has to be seen, sir. He cannot say that if 3% make a conspiracy to commit the fraud to the tune of 100 and one person keeps 70, other keeps 20 and 10, that the remaining portion would not be attributable to them. The attempt and the very purpose of assisting in generation of proceeds of crime would have to be attributed to this applicant very much, sir. Because he was very instrumental, because he was present at the time of extortion. He carried out the meetings with them. He made inquiries with the respective companies for through which the generation of proceeds of crime initially took place, sir. So for the very purpose of assisting in the generation, he cannot run away from that. So far as the in his possession, what has been found is, sir, 246 crore, 246 bitcoins was found to be transferred to him, which was secreted in the account of wallet of Sunil Ratilal Bagh. Additionally, sir, 26 lakhs USDT has also been found from the scrutiny of the wallet that we have carried out, and it runs
Whose
around
wallet? Whose wallet?
in the possession of this very applicant, sir. Addition to this, sir, the very 240 bitcoins, which he says that was transferred by Shilesh Bhatt to him. Sir, both the wallet which was found in the possession of Sunil Ratilal Bagh and this very applicant, nothing in common record which show that both the transactions are same. Both the transactions are separate, and in totality, sir, there are around somewhere around 500 bitcoins has been received by the present applicant, sir. So in his possession, the remaining portion would come for the concealment portion. One of the argument raised by them that I have been found in possession of only 246, so only that much role may be attributed to me. But concealment is one of the ingredient of the offense under section 3, sir. So he cannot run away that if nothing has been found from my possession beyond this, although I was found to have carried out the transaction for him, I may not be liable for that, sir. In this, I would like to place one judgment on God. Paragraph 9 would be relevant for this, sir. Sir, at page number 8, point number 9, sir. There is yet another aspect. There are prima facie materials to show that illicit mining had taken place. The prosecution in respect of the scheduled offence is still pending. The evaluation report of the department of so and so indicates that proceeds of crime valued at so and so. It is not known as to what happened to that said amount. The learned counsel for the petitioner would claim that the identification of proceeds of crime is sine qua non, and in its absence, no complaint in respect of the offence of money laundering can lie. This argument has no merit. The learned AST pointed out section 3, which defines the offence of money laundering and clarifies that the person shall be guilty of the offence of money laundering if the person is involved in the concealment of proceeds of crime. Then at page number 10, sir, the second paragraph on page number 10, I would be reading. In the light of the aforesaid statutory definition, one can safely hold that it is enough if the prosecution established that there was generation of proceeds of crime and the accused was involved in the offence or activity in connection with the proceeds of crime. If by a Houdini trick they vanish thereafter, ED need not establish the money trail. Since concealment of the proceeds of crime is an offence, the accused can be held guilty of the same. The ED need not demonstrate where the money eventually went. The accused, after engineering a disappearing act, cannot be heard to contend that they must be exonerated because the proceeds of crime has not been identified. So, sir, the present applicant has been trying to do the same thing, sir. In this respect, I would also like to place one another judgment of the last week only, which is on the similar line, because they have been claiming parity, citing some that the role of the other applicant was grave. I will be reading paragraph 8 first, sir, at page number 5, because similar contention has been raised by the applicant in this case. Sir. Para 5. Sir. The court further identifies that within 7 days of the arrest of the applicant, ED filed a prosecution complaint against the applicant and 52 other individuals. Notably, apart from the applicant, one Soumya Chaurasia, none other than the accused person, was arrested by the prosecuting agency, despite the fact that several of them are alleged to have played more significant role in the commission of the offence of money laundering and are alleged to have derived much larger proceeds of crime. So, because they have contended that Dhaval Mamani was not arrested, because one of the arguments raised on behalf of them was to that effect. Then I would like to take the honorable court to page number page number 16, sir. Paragraph number 36.
Judgment.
Of this very judgment, sir.
Yeah. This case, he is claiming parity with the accused person who are not arrested.
So no, he is claiming parity for the who has been granted bail as well, sir. It is there in the observation.
Where is it?
Then honorable could be pleased to see page number 9 of the judgment, sir. Paragraph 17. It is submitted that the applicant is also entitled to bail on the principle of parity. It is submitted that several co-accused persons who have already played a far more significant role in the alleged scam have already been granted bail, including so-and-so granted bail by the Supreme Court, sir, which they have also been claiming in the present case. Now I take the honorable court to the relevant paragraph at page 36 of the judgment, sir. Paragraph 83. be reading for this judgment at page number 41, sir. Paragraph number 95. In this context, it is also relevant to note that the Supreme Court has repeatedly observed that principle of parity cannot override the statutory restrictions granting the governing the grant of bail under special statutes, including the Prevention of Money Laundering Act. In view of the aforesaid circumstances, the court is of the considered opinion that the applicant cannot claim the benefit of parity merely on the ground that certain other accused have not been arrested or have been arraigned in the prosecution complaint without the arrest. The argument of parity raised on behalf of the applicant, therefore, does not advance in his case for the grant of bail. In addition to this, I would also submit that if the Honorable Court would see the order of the Apex Court, so it has been passed by the Apex Court because the applicant Shailesh Bhatt has approached the Apex Court invoking the SLP, that is the article invoking Article 136 of the Constitution, whereby the powers of Apex Court are quite vast and it cannot be.
Point out from their very order, the bail is granted because of exercising Article 136.
Because
If that is the submission, then your submission would be each and every matter under Article 136 that would not apply to the trial court.
no, because the order does not find mention that Section 45 or the conditions of one, because SLP, because Apex Court can grant the relief considering there is any statutory restrictions or not. Court can bypass it because the powers of Article 136 cannot be limited by any statute.
So you mean to say if Honorable Apex Court has considered the case of one accused,
Sir.
and if another accused approaches with a lesser role, then his case should not be considered because that is under 136.
No, I'm not saying that it need not be considered. I'm saying that the statutory, because here the application is under 483, which has to be decided on the parameters of Section 45 read with the discretion under 483. So my submission only is to that effect only, sir.
That can't be the submission.
Because the powers under 33 would not be bound by the powers under because Supreme Court need not bound its power by 45 or other statutory limitations.
Just like every accused argument seems to be very, sounds very good. Your argument also sounds good, but that can't be.
Yes, sir. But considering the judgment of the Chhattisgarh High Court, which is passed recently, sir, it is the last week's judgment. The Supreme Court, the High Court has considered the roles
What
similar.
Supreme Court has said,
Yes.
even in ED case, if parity is not a principle,
Yes.
no doubt. So what another thing is, in each and every case, independent role is to be asserted.
Yes, sir.
Now you will have to point out what is his role and what is that role. Now case law we will
Yes, sir.
consider.
So far as
Now you tell me who is the main accused.
Sir,
And how his role would be different from other accused.
my submission would to that effect would be firstly for the generation part, he has to be attributed the similar role because he was instrumental in generation of the similar amount of bitcoins, that is 2091. Thereafter, he has received 246 bitcoins
Now you
and
point out how he has been instrument in generation of that 209. It can't be your mere imagination.
no, not mere imagination, because firstly he was found to having been conspired with the other co-accused for making a conspiracy to extort the bitcoins. He has made inquiries with the hacker named Manan Shah to with respect to the BitConnect company, after which the extortion took place.
But then even if we take as good as main accused, then also same thing.
My submission would be restricted because beyond 2091,
Beyond that, see,
beyond
you-
2091, we cannot
you said
attribute the role.
beyond 2091.
Beyond
Your
2091, we
investigation
cannot attribute the role because that is the total procedure which has been.
It might
Yes.
happen beyond, during
Yes.
the course of initially it would be A is a main accused. Subsequently it would turn out C is a main accused. Subsequently it might happen
Yes.
F is a main accused because that would reveal during the investigation. You point out from the factual aspect.
That would be the submission.
Anyway, yeah.
Yes.
thing if I were to.
No, no, now you-
Ramesh bhai Dabi judgment is the direct answer.
Ramesh
of
bhai,
parity.
Ramesh bhai Dabi.
After-
Which I have added.
Yes,
That line is direct answer. but there is
after
a
Ramesh,
commission work.
after Ramesh bhai Dabi, there is judgment of the Honorable
Yes.
Supreme Court where it is stated here, parity is not a law. And one is by the two judges bench of the Supreme Court, one is by the three judges. The individual role has to be ascertained. So now Ramesh Dabi,
Yes, that will be accepted. I am not on this, but I am on that aspect is my understanding that the Supreme Court has granted bail and the Honorable Court cannot grant it.
I'm not saying we cannot
No, no,
grant
no,
bail. I have not said that.
that I
we
have
can.
not accepted. Because it is under 136 or that, it is law of the land. But so far as that principle of parity, you cannot claim as a matter of right. Unless,
Individual role has to
an
be-
individual
that
role.
is the law. That is the
That was a case, Ramesh bhai Dabi was a case where the main accused who was attributed the role of 376 was considered.
Please.
And this, the other with lesser role was not granted. And I would be more,
My submission is that.
I would be more cautious because that sessions court was the very same court from which that order has emerged.
That I have.
So I am aware, but
Jai Shri Ram. So no, I have allegation against me is much later and therefore I am declaring.
you have given notes, yours.
Yes, there is a note of effects. So at the top of the submission, the honorable would find the note with respect to the status of investigation. There are, against it, there are some documents which we have received from the wallet, which are under scrutiny for the investigation.
But as on date beyond 2091.
As of name, beyond 2091, it is the, as on date. As on.
You want anything? Want the papers you want? File for my perusal, I would be asking.
And since I am summoned after 4 years and LOC is continuing since 2022, we are in 2026. So this becomes relevant in my submission order. That this investigation in fact is continuing illegally in my submission. And every now and then I am called my lordship to appear before the IO. If the charge sheet is filed in 2023 my lordship, I read only 2-3 paragraphs my lordship that will make things very clear. May I, my lordship?
But it won't be, we have no concern with this issue.
No, my lordship, it goes to the root of the matter whether
It
the
does not
ED
go, I am not going to hell whether it is legal or illegal.
No. I'm just in the aid of my application, my lordship, for resigning or suspending the LOC. I'm making a
You
case
can
that
make your submission good on the point of LOC. But whether the investigation can be continued, not continued, whether it is ED probe or whether it is probe under the CRPC, DNSS, that would be a different thing.
fine. So my submission is only linked to that, my lordship. I'm not seeking any other relief as far as I'm fighting. is concerned.
Because your relief is pertaining to LOC.
Yes. So my lordship, then I have nothing, see, my lordship has raised the issue that my client, my client has appeared on 3rd of March 2026 before the IO. IO has raised almost 40 questions asking for a lot of information over of covering period of more than 10 years. So my client has written an email seeking time because he is finding it difficult to get this information. That is the point. Second point I was making about my lordship that this issue about investigation continuing in Singapore and they are waiting for some information. So this, as per the record of this honorable court, my lordship, ED has not asked for any permission from this court or asked the honorable court for issuing letter rogatory to Singapore authority in connection with their investigation. It is the CBI which has sought the permission and which have been granted. So the letter rogatory has been allowed by the Magistrate Court of Delhi as far as the CBI case is concerned. It is not with respect to ED case, my lordship. So this statement which was made by the counsel of ED is not correct with my point, my lordship. So as far as my submission, if I confine myself, my lordship, the investigation is complete. The charge sheet is filed in 2023. I have cooperated with the investigation. I am providing all the information, whatever I can. And lastly, my lordship, even in case of the SFIO case, which is pending in Bombay Special SFIO Court, where my LOC has been suspended by the honorable court there. In that case, my lordship, the allegation against me are quite serious, more serious than what is there in this case. Here, the punishment, maximum punishment is from minimum 3 years and maximum 7 years. Whereas there the allegations are of 447, where the punishment can go up to 10 years. So there the court has found it appropriate to suspend the LOC because the investigation is complete, charge sheet is filed. So I'm pleading the same ground, my lordship, that and I'm willing to abide by the condition. I'm offering myself condition that I may be directed like the Bombay SFI court, saying that whenever I travel, I give them intimation 17 days advance of my place of travel, date of travel, date of return, what place, contact number, etc. So that they will know my whereabout whenever I am away. And the fact that, my lordship, I have scrupulously complied with the permission of the Honorable High Court as far as the whenever I was allowed to travel. So I have not violated any condition. My property, everything is here. And in this intervening period, my lordship, in the last 4 years that when I was not called, I have not done anything which will hamper the investigation of the PD. So
Yes.
So far as the further investigation is going on, that is, would be dealt by the provisions of section 44 and not with the 173 that the judgment
We
is.
are not concerned with that.
Technically, sir, with respect to the LR, they have said that no such LR was issued by, but we have approached this honorable court and the honorable court was free to grant the LR, and we have sent it to Singapore. So that is not correct submission on the part of the London Council. So far as
That is-
40,
LR is issued against.
yes, that is.
my submission is based on the court record. I could not see it online. So
That would not be part of the this prosecution made subsequent to that itself. And so far as the question, the 40 questions were asked from him, audio is bound to ask the questions, but so far as the cooperation that is sought with respect to the crime period only, the document was sought from the concerned, and so far as his cooperation in the investigation, that has not come on record. That he would be providing document in what and what some time.
Yes, in the email.
Yes,
you can
yes,
write
yes.
that.
He has given the email to the IU, but no such period has been defined in which time period he would be bringing the report.
He is sought in the judgment is sought at later dates. So
Later-
later said that he will not provide.
That
He is not
even
responding.
I'm not saying that
Yeah.
he's not coming with the. I'm saying that he has not defined any period in which he would be giving bringing with the report before the IU.
Clearly, with my lordship, the issue here is that ED investigation as far as my rule, that day, London Council also pointed out how much money has flown into my company and flown out, and what is the amount allegedly retained by me. So as far as and all the, in these economic offices, all the document, it is the documentary trail. I mean, if the money has flown into my account or my company's account, it is a matter of trail. I cannot do, anything outside this banking system because the amount allegedly involved are huge, right?
Yes, so most of you are odd now.
Yep.
Okay.